Why does Social Security send you to a psychologist for a consultative evaluation when you pursue disability benefits? I'm Jonathan Ginsberg. I'm a Social Security disability attorney. I represent clients in all 50 states, and I'm able to have a national practice because disability hearings are now done by telephone or video. So that means that I may be in one state, you may be in another state, the judge in a third state, the vocational witness in a fourth state. It really doesn't matter. Hearings are all done virtually now for the most part. So if I can be of help to you, no matter where you live, I encourage you to visit me online at ssdanswers.com. I've got a case evaluation form there. If I can be of help to you, I would be happy to do so. I want to talk to you today about psychological consultative evaluations. And these are evaluations where Social Security sends you to one of their doctors, and they use consultative doctors for both physical as well as psychological impairments. I want to talk about the psych consultatives today. We'll talk about the physical ones at another time. But generally speaking, if you allege any type of anxiety or depression or PTSD or any kind of mental health problem, that will trigger Social Security to send you to a psychologist for a review. And people say to me, well, you know, I'm going to my own psychologist. Why do I need to go to their psychologist? What's the point? Well, there's a couple reasons for it. One is that Social Security has an obligation under the law to develop the record. And so as part of that, they have a procedure where, for the most part, they're going to send almost every claimant out to either a physical or a psychological consultative evaluation or both, just to make sure that that objective of developing the record is satisfied. You may have your own record, but rather than analyze it and say, yes, there's enough here in your own record, they're going to just send you out for one of their doctors. So that's part of it's just to fulfill their obligation to develop the record. The second thing is that Social Security is looking for more objective medical evidence, and I think their concern is that if they only get records from your doctor, that doctor might not be fully objective. That doctor may be invested in you're getting on disability benefits. It may not be completely truthful about what the degree of impairment you may have. And you may have heard of this. There was a case a number of years ago, an attorney named Kahn, who was involved in a kind of a conspiracy with some doctors and with some judges, where basically they faked a lot of medical records and reports and got people on benefits. I think this was in Kentucky or West Virginia, and it was a big scandal for Social Security. And of course, Congress looks at this and says, well, that means that the whole system is rotten, so we're going to really push Social Security to send people out for consultatives. It's kind of an overreaction. But as a result, they want to feel like at least some of the medical evidence there is not potentially biased, because the doctors on their panel really have no dog in the fight, as it were. They're getting paid a flat fee for an analysis or for an evaluation, but hopefully that's going to be a little more objective. And as part of this whole Eric Kahn fiasco, SSA had the brilliant decision, a move to eliminate something called the treating source requirement, which basically said that they would give controlling weight in a disability case, excuse me, to records from your longtime treating doctor and less weight from consultative doctors or non-examining doctors. Well, they got rid of that. So what that means is that Social Security can deny your case even if the basis of the denial is one of the consultative doctors who saw you one time, or even a non-examining doctor who never met you at all, who just looked at the record. But they want to give judges the leeway to say, you know, I don't think this treating doctor is very credible. I think there's something funny going on here. We're going to deny the case based on some non-examining doctor. I think, again, it's an overreaction to a problem, and obviously there was some corruption going on there. But I think most of the time a treating doctor is going to be a much better source, obviously, than a one-time doctor visit. I think most judges, even without the treating source rule, most judges recognize that a doctor who's seen you for 5 or 6 years is going to have better perspective than someone who saw you for 45 minutes, 3 months ago. But nevertheless, it is within Social Security's purview. It's within the right of the judge to deny your case based on a non-examining doctor's one-time visit for you. So they send you out for consultatives because it helps develop the record, and it gives them an angle, a legal reason to turn you down if the judge wants to do so, if the judge is suspicious about the motivations of your treating doctor. Like I said, I think it's not doesn't happen that much. Again, most judges are trying to do the right thing, and if they are really, really suspicious that a doctor who's maybe known to them as being overly generous in terms of issuing functional capacity reports that show somebody is disabled, this gives them an angle to give that less weight and to counter that. But I think, again, most of the time, if you've got ongoing treatment records from a legitimate doctor, that's going to carry the day, because judges, again, that's the reasonable thing to do, and I think most judges really do want to be reasonable. So that is a long answer to a short question. Why does Social Security send you out for consultative evaluations? That's basically the reasons why. Please visit me online, ssdanswers.com. You will find there a place where you can request a case evaluation, no cost. I'll take a look at your case and give you an idea what I think. I also have a free Secrets to Winning Disability Survival Kit download. Comes by email, gives you a lot of information about what I've learned over the last 25 plus years about Social Security disability and its somewhat unusual ways to analyze cases, but maybe you can put that to use for you in getting yourself approved. And of course, I encourage you to reach out to me either through SSD Answers or leave me a comment on the video at YouTube or on Facebook, and if I can answer your question, I will do so without giving legal advice. I can't do that on YouTube, obviously, but on YouTube comment section, but if I can help you in any way, I'd be happy to do so. So again, ssdanswers.com, or leave me a comment, give me a thumbs up on this video if you thought it was useful, like it on Facebook, subscribe to our Facebook page, subscribe to our YouTube channel. All these things help me get the word out about disability, about what I do. And again, if I can help, let me know. For now, this is Jonathan Ginsberg, wishing you all the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.